right. Well, for those of you that are freaking out a little bit, congratulations. I think you do understand it. You're getting the same response that we had after the first time we heard about the regs and read those. You can see things don't fit together perfectly. That's why they solicit comments. And hopefully we'll have some changes that'll come out that will give us better guidance. But again, the green stuff is proposed. It's not the rules yet, but they could be the rules at any point starting today. So, all right, we're going to go through a series of scenarios here and visit about some case law. Scenario one is the sex assault. You're the high school principal. Cindy comes to you and reports that Dylan grabbed her in the parking lot last night after practice. According to Cindy, Dylan dragged her into his car and forced her to perform fellatio on him. So that's the scenario we're looking at. What should you do? How should you investigate this? Number one, reporting sex assaults to law enforcement. I hope you all know there is a state statute that says the principal or their designee, basically when you're aware of a violation of the Student Discipline Act that also is a violation of the Nebraska Criminal Code, you're required to contact law enforcement. This is the one that sometimes upsets OCR. They don't like that we have to contact, especially on special ed students, but it's our law. We don't have a choice. If it's a law violation, we have to contact law enforcement. So step one is once you get this report, call the cops. But you still have to do your Title IX investigation, but don't tell the administration from Forest Hills that that's what you're supposed to do. In this case, we had a high school girl who alleged that a boy sexually assaulted her at school. And so this gets reported. Principal and the superintendent did a good job off the bat. They immediately contacted the school resource officer and contacted the sheriff and said, hey, we've gotten this report. Fantastic. So step one's checked off. They then look at the security footage, and this is where things kind of go off the rails because the girl, Jane Doe, had reported X, Y, and Z happened. They looked at the footage, and it didn't really follow what she had reported. So I think what we had is a case of the principal going, I'm not sure this is so true. And so he didn't do the best job of interviewing witnesses. He interviewed some, didn't record anything, didn't take any notes. That's not a good step. She apparently talked to her friends right after this. He didn't interview any of those people. He did not try to get a copy of the rape kit report. Did a lot of shoddy work in terms of his investigation. And so it just kind of sat there. Now there's a dispute. The school said, hey, the cops told us not to do our own separate investigation. And we get that report here a lot. And they say, hey, don't screw up our criminal case. Yeah, fantastic. We don't want to screw up your criminal case, but we also have Title IX obligations. And that includes interviewing and doing our own investigation to see if we have to take remedial measures or corrective measures. And so when a cop tells you that, you can't listen to that advice. You have to do your own investigation. So what the principal said is, I was told that, so I stopped. Plus, let's face it, they're the cops. So they've got better resources. They're better trained. Their investigation is going to be better than ours anyway. So they kind of sat back and weren't doing a whole lot until 2 weeks later, there's a rumor that the same kid assaulted somebody else. Now they start to take it a little more seriously, both the cops and the school district. They put some interim measures in place, some remedial measures. They offered counseling for the girl and things like that. They finally removed that they were in classes together. They finally took the girl or the boy out of those classes, but that took 2 weeks. They still hadn't disciplined the kid. It took a month. They decided, okay, we're not going to let him play basketball anymore. And so they took him out of there. But really, they sat back. They put the remedial measures in place, but all this harassment was occurring. She said his peers were harassing her. He was harassing her. Keyed the car, was blocking exits so she couldn't get by, was making noises at her in the hallways, stuff of that nature. The school basically did nothing in response to that, which was not a good thing. So we've got the assault, they did nothing. We have all this harassment that's occurring, they do nothing. They sat back and waited for the cops to do their investigation. It finally gets charged after the rumors come out that this other assault has occurred. And so he gets charged. 7 months in, he finally pleads guilty. At that point, the school finally institutes discipline. They gave him a whole 5 days out of school suspension. That was it. And then 11 months after the assault occurred, they sent out a letter that says, case closed. That was it. So it took them 11 months to close this case. Family, obviously not happy, sues, files a complaint and sues under Title IX. School says, we weren't deliberately indifferent. Hey, we looked at the videotape, we contacted law enforcement, we got our counseling, we did all those other things. So we weren't deliberately indifferent. The problem is the court said, yeah, you took some steps, but then you just sat there. you didn't actually make a final decision. They said you admitted you were waiting for the cops to do their investigation and make their determination. And you really didn't do anything to the perpetrator until he pled guilty in court. And so the court said, you failed to interview friends. You waited months for someone else to make a conclusion. And he said, based on that, a jury easily could find that this was clearly unreasonable and represented deliberate indifference by the school. The key we want you to take away from this is you can't sit back and wait for the cops. You have to do your own investigation. And you have to have a timely conclusion. Waiting 11 months, waiting 7 months, that's not going to fly. As we said, they had that 60-day timeline flying around, not even close, and there was no legitimate reason to extend it out. And so we come back to this Q&A on sex assault that came out in September of 2017. The focus from them is going to be, is your response prompt and equitable? That's really what they're hammering on in these new regs too. They want to make sure that you've adopted and published this grievance procedure. And that was a discussion we had here yesterday. Do we really have to put all of these grievance procedure requirements that are in the new regs into writing, give them to people? I think the answer is yes. They're telling us we're going to have to, if we want the safe harbor protections. And we have to provide these prompt resolutions of the complaints. Here are the factors they're going to look at. Does it provide notice of the school's grievance procedure to everybody, students, parents, staff members? That's number one. Number two, do they apply the grievance procedures to complaints filed by students or on their behalf alleging sexual misconduct? So not only do we have them, are we actually using them? Do we have an adequate, reliable, and impartial investigation of the complaints, including an opportunity to present witnesses and other evidence? This is coming from some of those other cases that what was driving this. Hey, we didn't have a chance to defend ourselves. We had no due process. And the other part of that too is they want trained investigators. They have hammered on these people need training on pretty much everything as it relates to Title IX. Designates and follows a reasonably prompt time frame. So again, they're not saying 60 days, but that still is a good guidepost. But they do make clear, don't rush an investigation when there's good reason not to, but don't drag your heels when there's no good reason to do so. So notify the parties of the outcome of the complaint. That has to be in writing. Provides assurance that the school will take steps to prevent reoccurrence of sexual misconduct and to remedy its discriminatory effects. So again, make sure we're putting remedial measures in place, and make sure you follow up with both the victim and the perpetrator to make sure things are going as they should. So here's another green slide. This is some of the changes they're talking about. They want equitable treatment. And again, remember the driving force was those college cases where some of the accused were allegedly getting railroaded. And so we want equal treatment. So if you're going to do one thing for one side, you have to do the exact same thing for the other. They want notice of formal complaints to the respondent. They want that to be in writing. They want an objective. They want fair and unbiased people throughout this process. And as they talked about earlier, that's why they want different people doing each part of this investigation. They think if one person's doing it, you have a greater chance of bias in an unfair process. Unbiased administrative actors. They want the presumption of innocence. You cannot assume anything negative about either party based upon anything. They want a reasonably prompt resolution. We've talked about that. Description of potential sanctions, remedies, and available supports. They talk about this repeatedly in the new regs. You've got to it's all about notice. What could happen, what's available to me. And they also have a description of evidentiary standards that are going to be used as they talked about earlier. Are we going to use clear and convincing evidence as a standard? Are we going to use preponderance of the evidence as a standard? More changes. It would afford both parties the right to question the other party. Imagine how much fun that could be in a sexual assault case. It may be in written form in our schools in the elementary and secondary context. It may be a live hearing. We're not required to have a live hearing. Universities and colleges will. Questioning would occur by advisors of each party, no personal confrontation. So they have taken into account, okay, it's a sexual assault case. We're not going to allow the perpetrator, alleged perpetrator, to question the victim and vice versa. We're not going to have this circus kind of thing. And they've actually said if they don't have an advisor during that portion of a hearing, you've got to find somebody. You've got to find a fair and impartial person to come in and ask questions on behalf of that person. They cannot ask those questions. So what about Cindy and Dylan? First, obviously, call the police. Second, conduct your own investigation. As we said here, it's just, they don't say in the regs that the Title IX coordinator can't do the investigation, but as we've seen, when you work through the process, we just don't see how it's possible that they could to meet all of their other requirements. complete that investigation promptly. Again, try to shoot for that 60-day mark if you can. Take appropriate discipline with Dylan, but also, do you need to send him off to the student assistance team? What we've seen throughout the years is when these violent people, sexual or otherwise, do these things, they may be qualified for special ed and they've never been evaluated. It's never been considered. So you do have to take that into account. Do we also need to do that in addition to the stick? Do we have to give them a carrot? That kind of thing. Same with Cindy, we have to accommodate her. Does she need a referral to the student assistance team? What other services does she need? And you need to follow up with both of them to make sure that we're continuing to give them what they need. All right. How is the school protected if the student is found not guilty 6 months later? Great news. You're not held to the same standard as the criminal system. So even if you choose clear and convincing evidence as your standard, that's higher than typical. In criminal court, it's beyond a reasonable doubt, right? So it's very possible they can be found not guilty there, and they still are guilty. You know that the allegations are true under your standards. Plus, sometimes you flat out get it wrong. Let's take the Doe case that we just looked at. Let's say they had said, nope, we don't think he did it because we looked at the videotape. It doesn't corroborate with what she alleged. So we're saying no. And then 7 months later, he pleads guilty. It happens. What the OCR is saying, you still have to have a fair and equitable procedure. It's just like a criminal court. They don't always get it right. I mean, OJ's walking around. So, you know. Let's see. There seems to be a trend where schools are doing more than the police. Yeah. How does that play out in the hearing? Well, and sadly, I'm laughing because in a lot of our communities, you're right. And so how does that play out in a hearing? That's why they're having you do the investigations. That's why they want you to be trained. That's why they're hammering on these things, putting the police aside. Hey, if they gather evidence and they're willing to share it with us, you can and should use it. But this is why I think they're hammering on you need to be trained and you need to be fair and impartial, unbiased, and all those things, because you essentially need to act as a cop to some extent.
Punishment versus access.
What do you mean? Punishment. She's talking about punishment versus access. Criminal courts, it's after punishment. Under Title IX, this is all about access to education, right? And so we just need to make sure that everybody's getting the access to education that they're entitled to under Title IX. So there are two different approaches there. Can this unbiased investigator be from another school? This is one we kicked around, and we thought, you know how when you have a student discipline hearing and you need a hearing officer and you call your neighbor, you go, hey, I tell you what, you do this one for me and I'll do your next one. This is a possibility. You know, do they have proper training? Do they have all the things they need? But is this something that might come up? Yes. I mean, it's one of the things we have kicked around as to how are, especially our smaller schools, how are they going to be able to comply with all of these requirements?
One thing I want to drop in here just briefly as we talk about student discipline. Senator Vargas has introduced a bill which would actually make it more difficult to appoint hearing officers how they have typically been appointed. This notion of when a school finds a hearing officer, there are more requirements for it. So it could be that the student discipline side is changing, which may inform this notion of you can't call your buddy who you know is in the bag for you, who's going to do what you want him to do or you want her to do. Somebody could raise that, and that's coming up in our student discipline context outside of Title IX, like literally as we speak. So I throw that out there.
All right, another question. I like to have a second administrator in a student investigation as a liability safety measure. And we typically recommend that you have two people there. Our district has only two administrators. Is this a Title IX conflict to use both administrators? No, but you're gonna have to hire more people. I mean, you're seeing the frustration and the difficulty that these new regulations are proposing. It's like we said, they have Chicago in mind. They have the University of Michigan in mind when they're saying, oh, everybody's got all these people. They don't have, I don't know, Central City, Nebraska in mind. That's not who they're thinking of when they're talking about these things. And so we are going to have to adapt. Number one, they're getting comments, so we're hoping they will adjust their regs. If they don't, we are going to have to adapt and figure out. I mean, we've talked about a teacher may have to play a role. You're going to have to get your best teacher to play one of these roles. So that's a very real possibility. Is there a list of people that are properly trained? No, not yet. But my guess is there will be if and when these regs pass. Under what circumstances does a parent need to be present, and what if they do not allow their child to be interviewed? Great question under these regs, because typically in a typical student discipline matter, they have no right to be present, and they have no right to say, you're not going to talk to my kid. Now we have these regs that say, hey, they get to have the advisor of their choice. That advisor could be their parent. And what if they say, you're not talking to my kid? I think they have that right under these regs. So you can see, again, there's an inherent conflict under what the law is in other contexts and what they're saying it is here. And so that is going to make things way more difficult. Oh, Jason Dolliver says, would somebody please share the new regs with the legislators that think schools spend too much money?
It's like, yeah, Jason, we'll send them. I see what you're saying.
We'll send them to the feds. We'll send them to the state. Yeah, and you're exactly right. I mean, you're putting this truly is putting an unfunded mandate on us. This is a lot of work. It's a lot of training, and you're just going to need more personnel to actually do it. So it's a good point. In light of the earlier information, if my elementary principal is Title IX coordinator for high school, can high school principal conduct the investigation? This comes back, yes, but you're still going to need, you've got that conflict with the student discipline, imposing the discipline, and we're going to have the same conflicts we've talked about. We simply, the way they've set it up, you simply need more bodies. And I don't know that we can give you a better answer at this point. Hopefully these proposed regs maybe will be a little different.